In 2014, after a whirlwind year for same-sex couples, the United States Supreme Court struck down portions of the Federal Defense of Marriage Act. And then the United States District Court ruled that Pennsylvania's ban on same-sex marriage was unconstitutional. This is amazing. But now what do we do? Stay tuned and I'll share my tips on legally planning for your same-sex partner.
Welcome to this episode of Your Legal Legacy with your host, Attorney Michelle Conti.
As a result of the Pennsylvania court's ruling not being appealed, it is time to consider what to do now that the legal landscape has so drastically changed. For the first time, income, estate, and gift tax planning, as well as other aspects of your will, trust, and jointly owned property in Pennsylvania will be the same as a married heterosexual couples. Legally, same-sex couples can now file joint tax returns or married filing separately. These are things that never had to be considered before, which makes it the perfect time to reevaluate your estate plan. First and foremost, as with any couple, I recommend a will so that you know that your wishes will be seen to upon your passing. This process also needs to be done with tax planning in mind so that transfers can be accomplished in the most efficient way possible with respect to taxes. The same is true with your assets that you can and should put beneficiary designations on. These are non-probatable assets, which means that they do not pass through your will. These include things like life insurance, annuities, IRAs, 401ks, 403bs, and even your pension. What's really important now is that same-sex couples not take the view that because they are married, that wills are no longer important. I say this because one of the biggest misconceptions that I often hear is that without a will, Pennsylvania's law will split a person's assets among their kids and their spouse. But is this what you want? Another issue to consider is the ownership of property. Should it be held individually, which causes the issue of probate upon your partner's passing? Possible loss of your home and potential tax liability? Or do we title it jointly to save time and money? It's important because now that you are married, there isn't any transfer tax. But if your estate is large enough, it may make sense to separate property to even out any tax consequences or to protect you in the event of a divorce. There are so many issues that have reared their ugly heads now that the state has ruled that same-sex marriage is legal. Don't get me wrong, this is incredible news. But with this news comes some heavy decisions that need to be made. So let's sit down and talk through what's the best planning strategy for you and your family. I'll see you soon with more tips on creating your legal legacy.
Thank you for watching Your Legal Legacy. For more great information, visit ContiLawLLC.com.